agreed recommended sentence to the court that there would have to be a period of consecutive time. Is that correct, Mr. Strang?
That's correct, Your Honor.
And Ms. Robertson?
Yes, Your Honor.
All right. All right, the defendant had pled guilty to count number 1 as amended. It was a murder charge. The state of Ohio entered into a plea arrangement with the defense to amend count number 1 to involuntary manslaughter, a felony of the first degree, a violation of 2903.04a. As a felony of the first degree, there's an indefinite term of incarceration with a minimum period of time and a maximum period of time that was discussed, and the defendant was fully apprised of all of that. Count number 3 is also an indefinite period of time. This is a felonious assault felony of the second degree, a violation of 2903.11a1. And the court advised the defendant of the Reagan-Tokes advisement, and she did sign that as well on that date with her counsel. And we did review all of the language there. The court's obliged to do this at the time of sentencing per the case law. So I'm advising you again, the same things that we talked about before. I want to make sure that you understood them then and you understand them now. Do you understand, Ms. Vaden? All right. So I'm reading to you, and I'll have this placed right in front of you again. Okay, as this is being handed to you, Ms. Robertson, you'll see that your attorney's signature is there. That was done in front of me, correct?
That's correct, Your Honor.
And Ms. Vaden, that is your signature that you understood all of this, yes?
Yes.
All right, so let us read this again together. The defendant has also been notified, paragraph 1, that it is rebuttably presumed that the offender will be released from the service of the sentence on the expiration of the minimum prison term imposed as part of the sentence or on the offender's presumptive earned early release date as defined in section 2967.271 of the revised code, whichever is earlier. And paragraph 2, that the Department of Rehabilitation and Correction may rebut the presumption described in division B2C1 of this section if at a hearing held under section 2967.271 of the revised code, the department makes specified determinations regarding the offender's conduct while confined, the offender's rehabilitation, the offender's threat to society, the offender's restrictive housing, if any, while confined, and the offender's security classification. Paragraph 3, that if as described in Division B2C2 of this section, the Department at the hearing makes the specified determinations and rebuts the presumption, the Department may maintain the offender's incarceration after the expiration of that minimum term or after that presumptive earned early release date for the length of time the Department determines to be reasonable, subject to the limitations specified in section 2967.271 of the revised code. Paragraph 4, that the Department may make the specified determinations and maintain the offender's incarceration under the provisions described in Divisions B2C1 and 2 of this section more than one time, subject to the limitations specified in section 2967.271 of the revised code. Paragraph 5, that if the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. Ms. Vaden, do you understand all of these paragraphs, and did you understand them at the time of your change of plea? All right. Prior to coming to the bench, the court did have the opportunity to review the entire case file. Although there was not a pre-sentence investigation report requested by the defense, the court has inquired as to the facts, and both parties have had the opportunity to speak to the court and answer any questions and provide any information. I've reviewed 2929.11 for the principles and purposes of sentencing, 2929.12 for the seriousness and recidivism factors, and 2929.13 and other revised code sections for felony sentencing. the court has formulated the following decision based upon the overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others and to punish the offender using the minimum sanctions that the court determines, accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution, and the court has considered the relevant sentencing guidelines provided in revised codes 2929.11, 2929.12, and 2929.13, as well as 2929.19. At the time of the plea, it was agreed that the offenses that the defendant pled guilty to would be non-allied offenses of similar import, and that there was an agreed recommended sentence of 14 to 20 years with no early release, that period of time being on the, I should say, not including the Reagan-Tokes indefinite period, or in other words, the maximum sentence. The court will follow the party's recommendation and sentence within the range. As such, there will be a consecutive sentence, and the court has reviewed each of these crimes that have been committed here. And the court will note that it is employing consecutive sentences consistent with the party's agreement, and also pursuant to 2929.14C4B, the court imposes prison terms consecutively, finding that the consecutive service is necessary to protect the public from future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger defendant poses to the public, and that at least two of the multiple offenses were committed in this case as part of one or more courses of conduct, and the harm caused by said multiple offenses was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the defendant's conduct. The court also imposes consecutive sentences pursuant to 2929.14C4C, finding that consecutive sentence service is necessary to protect the public from future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger defendant poses to the public, and that defendant's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. Ms. Vaden, did Mr. McQueen help dispose of that body? Why did you send that text message? I'm sorry?
Due to what I was going through, he wasn't answering the phone, and it was kind of supposed to be like a message basically saying, are you okay? Like, basically, like, call me, make sure you're okay, because I don't want you to be missing, like, next. It's kind of supposed to be like a, you know what I'm going through, please don't, like, put me in a situation where it was just kind of like a
The text is, you are going to be missing next.
yes, but like I said, it was a message. We were texting, and it was like a message, basically me checking on his whereabouts to make sure that he was
For his welfare. Okay, understood. All right, I'll take that then, as you say. I have reviewed the council's sentencing memorandum as well. As to the involuntary manslaughter, felony to the first degree, the court will sentence you to a period of 11 years. That is the maximum sentence on that count. This will be the qualifying offense. As such, per Reagan-Tokes, there's a 5.5-year additional time that is possible pursuant to the language that I've already read to you. On this count alone, you are to serve a minimum prison term of 11 years with an indefinite prison term of 5.5 years. On this count alone, then, that would be for a maximum prison term of 16.5 years. As to count number 3, this is the felonious assault, felony to the second degree. The court imposes a prison term of 8 years, which will be run consecutively. As to the gross abuse of a corpse, felony of the 5th degree. Where you employed the use of other people. With such careful intention to have them packaged up, and the knowledge over a 7-month period to the harm caused to the family, the court will sentence you to 7 months. All of that period of time will also be consecutive pursuant to the court's findings. Your sentence is 19 years and 7 months. You are to serve a minimum prison term of 19 years and 7 months with an indefinite prison term of 5.5 years. For the maximum prison term, then, I believe 25.2 years, or 25, I should say 25 years, 2 months. The court will ensure that the math is appropriate. Mr. Carson?
Yes, Judge, we agree with that calculation. We just wanted to make sure there was a PRC advisement if that had not already been done.
Have not done that yet.
Thank you.
On the felony of the first degree involuntary manslaughter, there's a mandatory minimum of 2 years up to a maximum of 5 years of post-release control supervision. On the felony of the second degree, there's a mandatory minimum of 18 months up to a maximum of 3 years of adult parole supervision. On the felony of the fifth degree for the gross abuse of a corpse, the adult parole authority has the ability to supervise you for a period of up to 2 years. It's at their discretion, or in other words, their choice. And if you violate any post-release control rule or condition, you may be subjected to a more restrictive rule or condition, a longer duration under supervision, or you could be sent back to prison even though you have done all the time to which you have been sentenced. You could get up to 9 months in prison for each rule violation. The total, however, for all rule violations cannot be any more than 1/2 of the prison sentence that you receive, unless the rule violation is for the commission of a new felony, in which case you could receive a prison term of the greater of 1 year or the time remaining on post-release control, in addition to any time that you receive for the new felony. The post-release control prison term must be served consecutively, which means one after the other, to any prison term that you receive for the new felony. The court will take back that Reagan Tokes advisement form from you after the proceedings here. And there is credit for time served in this matter, which the court has calculated. 234 days, which the court will put in the journal entry so we can have a clear record of that. Ms. Robertson, as to your motion, as to the defendant, yes.
Costs and fees,
All right. The court will waive court costs and fees, finding the defendant to be indigent, and will not assess those. Mr. Strang or Mr. Mr. Strang or Mr. McNair, any further issues from the state?
No, Your Honor. Thank you.
All right. Ms. Robertson?
No, Your Honor. Thank you.
All right, thank you. All right, thank you, everyone. Thank you all for being here. I would expect deputies who will have to be able to leave first, pursuant to your procedures. Mr. Strang, please keep your family here. Yes, you may. Mr. Strang, could you please have them? Are they going to leave first or second? All right. Thank you for staying seated. Yeah, they're good.